So I want you to picture a piece of paper, right? It's a legal defense, and it's scrawled from inside a prison cell.
Okay.
But it's not written in ink. It's literally written in the prisoner's own blood.
Oh, wow. That is, I mean, that's just a haunting image, you know?
It really is. It's this desperate, just visceral plea from a human being who is trying to defend his freedom. And he's doing it using, of all things, the principles of quantum physics and the scientific method.
Right. You have all that messy, agonizing reality of human suffering just right there on the page.
Exactly. But now I want you to contrast that bloodstained paper with, well, cold, dispassionate lines of code, like billions of parameters. Because for our deep dive today, we took that exact human plea, along with the indictment, the trial judgment, and the appellate ruling that put this man in a cage.
Yeah.
And we basically fed them into a jury made entirely of machines.
Which I gotta say is what makes today's custom-tailored deep dive so completely unprecedented. We aren't just looking at, a stack of Chinese legal documents here. We are looking at these really in-depth legal and logical analyses of this exact case, generated by 6 of the world's most advanced AI models. So we're talking Grok, Gemini, ChatGPT, Copilot, DeepSeek, and Qwen.
We basically let the algorithms review the humans. And before we get into what those machines actually found, I just need to be crystal clear with you, the listener.
Yeah, this is important.
We are diving into a politically sensitive case today, but our goal here is absolutely not to take political sides.
No, not at all.
And we are definitely not endorsing any of the viewpoints found in the original social media posts that sparked this whole thing. Our mission is purely to unpack the fascinating legal and, well, logical analysis provided by these 6 AI models.
And that is a crucial baseline for us today. I mean, we are treating this as an architectural review of human logic, right? We're completely stripping away the politics of the content itself.
Precisely. So let's set the stage a bit. Who is the man who actually wrote that letter? His name is Dr. Chen Jingyuan. He's a physics PhD, an independent scholar, and he basically spent his life studying complex systems and network physics.
Sounds like a pretty serious academic.
Yeah, exactly. But between 2019 and 2022, he used a VPN to get around the local internet firewall so he could read and retweet posts on Twitter. And that's his entire action, just clicking the retweet button.
Just click and retweet.
Yeah, and his account had fewer than 100 followers. But for this, local police broke into his home, they seized his electronics, and he was ultimately sentenced to 1 year and 8 months in prison.
I mean, a nearly 2-year prison sentence.
Yeah.
For a highly marginalized, almost invisible account, engaging with content on a platform that is technically blocked in his own country anyway. It's just...
Okay, let's unpack this, because what exactly was the crime that justified breaking down a physicist's door?
Right.
The official charge in the indictment is picking quarrels and provoking trouble. But wait, isn't picking quarrels an inherently, physical crime?
You'd think so, yeah.
Because when I hear that, I picture someone starting a bar fight, or vandalizing a bus stop, or causing a riot out in the street. How does a physical altercation charge apply to a guy just sitting in his living room clicking a mouse?
It's a great question. And to answer it, we really have to look at how laws kind of mutate over time. So in Chinese jurisprudence, this specific charge is widely known among legal scholars as a pocket crime.
Wait, a pocket crime? Like pickpocketing?
No. Think of it more like a giant, heavily elastic pocket.
Okay.
It refers to a crime with a definition that is so broad and so vaguely written that prosecutors can essentially stuff any undesirable behavior into it.
Oh, I see.
It absolutely was originally designed to handle street hooliganism, the bar fights, and the physical altercations that you just pictured. But over time, through various judicial interpretations, the courts aggressively expanded the definition of a public place to include cyberspace.
Wow, so they literally mapped a physical law onto a digital space? Yeah. But even with that expansion, there have to be specific guardrails, right? I mean, you can't just throw someone in jail arbitrarily for logging onto the internet.
Well, there's supposed to be guardrails. The legal threshold, which was clearly established by the Supreme People's Court over there, requires 2 very strict elements for online speech to actually become a crime.
Okay, what are they?
First, the person must be actively spreading false information. They have to be maliciously spreading rumors. And second, the spread of that false information must cause a severe disruption of public order.
Okay, and here is where I really want to bring in the machines. Because I was looking at the outputs from these 6 different AI models, and I'll admit, I was genuinely skeptical at first.
Sure. Yeah.
I mean, are we really trusting Grok or ChatGPT to understand the granular nuances of the Chinese legal code?
Right. It seems like a stretch.
But the thing is, they don't just read words, you know? They map logical dependencies. They map the rules of the law against the evidence provided. And despite having different programming, different training weights, totally different analytical styles,
Yeah.
they reached a unanimous digital consensus.
Unanimous. Every single one of the 6 models.
Exactly. They all concluded that the human legal documents fundamentally failed to prove the crime. The logic of the conviction completely collapsed under algorithmic scrutiny.
What's fascinating here is that it wasn't just a general disagreement. The AIs pinpointed the exact localized pressure point where the human judicial process just kind of abandoned its own rules.
Right.
If all 6 models agree the foundational logic of the case is flawed, it really begs the question of how the human judge actually rationalized the guilty verdict on paper.
Right. Because if Dr. Chen didn't meet those 2 strict criteria, how did the judge justify locking him up for 20 months? And I think that brings us to the psychological element of the crime, his subjective intent.
Yeah, the intent is huge.
Because to spread a rumor, you have to actually know you're spreading a rumor.
Exactly. The law requires malicious intent. You must subjectively know the information is false when you hit that retweet button.
And this is where DeepSeek and Gemini completely dismantled the court's judgment, because the AIs noted there was 0 direct evidence that Dr. Chen knew the posts were false.
None at all.
There were no chat logs where he told a friend, hey, I know this is a lie, but I'm posting it to cause trouble.
Right.
There was no confession. So to get around this lack of evidence, the court's official written logic was this, and tell me if this is crazy. Because Dr. Chen is a PhD with a very high level of education, he should have the ability to distinguish right from wrong. Therefore, he must have known the posts were false.
I mean, it is a breathtaking substitution of logic.
It makes absolutely no sense. That's like telling an English professor they are guilty of perjury because they retweeted a typo, arguing that, well, with a master's degree in English, they should have known it was spelled incorrectly.
Yeah.
You can't just substitute someone's resume for actual evidence of malicious intent, right?
That is the perfect analogy. And the AI models flagged this immediately as a systemic failure. In legal mechanics, what the court did there is called objective imputation.
Objective imputation.
Yeah, or essentially establishing an illegal presumption of guilt.
So walk me through the mechanics of that. How does objective imputation actually work in a courtroom?
Normally, the burden is entirely on the prosecution to prove an action and the mindset behind it.
Yeah.
You have to prove they did it and meant to do it. Objective imputation bypasses that entirely.
Oh, wow.
It penalizes an identity rather than proving an action. The court essentially said, you're highly educated, therefore your baseline capability demands that you agree with the state's version of truth. If your actions deviate from our truth, we will automatically impute or assign malicious intent to you.
That's wild.
They transferred his objective status as a scholar into subjective proof of guilt.
So they literally weaponized his own intelligence against him. And that brings us back to that visceral image we started with, you know, the prison letter written in blood.
Yeah.
This is where Dr. Chen fought back against that exact presumption, right?
He did. And Gemini provided an incredibly deep analysis of this specific letter. Dr. Chen used his physics background to dismantle the court's presumption of his mind. He didn't just say, I'm innocent. He cited Gödel's incompleteness theorem.
Wait, hold on. He brought quantum-level mathematics and formal logic into a criminal defense trial.
I think he did.
How does that even work? And did the AI actually validate that as a legitimate legal defense?
The AI found it legally and philosophically bulletproof. Gemini called it a dimensional strike against the prosecution.
A dimensional strike.
Yeah, because Gödel's incompleteness theorem mathematically proves that in any sufficiently complex logical system, there are truths that simply cannot be proven within that system. You can never have absolute closed-loop certainty.
Okay, I think I'm following.
So Dr. Chen used this, alongside the foundational scientific method of skepticism, to argue that his academic mind actually wires him to question everything.
Oh, I see. So he's arguing that a true scientist never looks at a piece of information and declares it to be absolute, undeniable truth.
Exactly. A scientist doubts, they hypothesize, they test.
Right.
Therefore, he argued, it is mathematically and scientifically impossible for the court to prove he possessed absolute knowledge of an information's falsity when he clicked retweet.
Yeah.
He was engaging in the messy, uncertain process of critical inquiry, not malicious rumor mongering.
That is just brilliant. He's essentially saying, my PhD doesn't mean I know everything is a fact. My PhD means I am qualified to know that nothing is absolutely certain.
Exactly.
But because the court couldn't read his mind, they just pointed to his diploma and declared him a criminal.
Which is a complete failure of the subjective requirement of the law.
Okay, but here's where it gets really interesting. Let's say the intent was completely fabricated by the court. What about the objective reality of what he was doing? Like, what was the actual content of these retweets?
Right.
Because if they sent police to kick down his door, I'm imagining he was posting, I don't know, bomb-making instructions or coordinating a bank run?
You would assume the material posed an imminent existential threat based on the severity of the state's response.
So I looked at the actual list of his retweets, and we are talking about political cartoons.
Yeah.
There was an illustration of an umbrella girl, which symbolized protest. There were photographs of candlelight vigils. There were some opinion pieces written by dissident scholars. And amazingly, there were official statements retweeted directly from the verified U.S. Embassy account.
And this is where ChatGPT and Copilot delivered their most devastating critique of the indictment. Remember, the first rule of the law, you have to spread false information.
Right.
For information to be legally defined as false, it must fundamentally be a falsifiable fact.
Right. Like if I say the central bank has run out of money and is closing tomorrow, that is a discrete fact. You can check it. It is either true or it is false.
Precisely. ChatGPT and Copilot meticulously pointed out that you cannot fact-check a cartoon.
No, of course not.
You cannot objectively disprove the sentiment behind a candlelight vigil. You cannot scientifically prove a subjective political opinion to be false.
Because an opinion isn't a fact. They literally took an artist's drawing of a girl holding an umbrella and legally categorized it as a false rumor.
The AI models recognized what was happening beneath the surface here. Because the authorities couldn't attack Dr. Chen's actions legally, since opinions aren't crimes, they decided to attack his sentiment politically.
Right.
But they tried to use the strict, objective language of the law to legitimize it. Copilot noted that by doing this, the court completely destroyed the epistemological boundary between a fact and an opinion.
Okay, but let's play devil's advocate for a second here. Let's pretend that a drawing of an umbrella can be classified as a malicious rumor. What about the second strict requirement of the law? The state has to prove that his retweet caused a severe disruption of public order. And I keep going back to the numbers here.
Followers.
Yeah, he had less than 100 followers. Over the span of 3 years, he had less than 100 total retweets. If I tweet something right now to 100 people, maybe like 5 of them actually see it in their feed.
If you're lucky.
Right. So I'm trying to picture how a prosecutor proves that an account that small caused a severe societal disruption.
That's exactly the contradiction Dr. Chen highlighted in his defense, and he used his expertise in network physics to prove it. He introduced the concept of self-organized criticality to the court.
Wait, what is self-organized criticality? How does network physics disprove a legal charge of public disruption?
So in complex systems, think of like a sand pile or a social media network. Small events usually stay small. For a single grain of sand or a single Twitter node to cause a massive systemic avalanche or societal panic, the system either has to be incredibly fragile or that specific node has to have a massive degree of connectivity and influence.
So it needs to be huge.
Right, a viral trend needs a massive hub to launch it.
So a marginalized node, like an account with under 100 followers, physically lacks the reach to trigger an avalanche.
It is mathematically impossible. He scientifically proved that his account was barely a drop in the ocean. It lacked the physical network capacity to cause severe disruption, even if you wanted to.
Wow. Did the prosecution offer any counter evidence? Like, did they show a spike in local crime or a riot or an economic panic tied to his account?
Well, the AI models scour the court documents, specifically looking for empirical data.
Yeah.
They found absolutely nothing. There were no metrics, no police reports of unrest, no economic loss statements. Not a single piece of real-world evidence was submitted to prove any disruption actually occurred.
You're kidding.
No. The court simply wrote the words, caused severe disruption on the final judgment, operating under the illusion that typing it into a legal document manifested it into reality.
I am genuinely struggling to understand how this survived the appeals process. I mean, if the network math proves disruption is impossible, if the intent is a fabricated presumption, and if the rumors are just cartoons, How does an appellate judge look at this and not immediately throw the entire case out?
This brings us to the most alarming part of the AI analysis, the systemic procedural collapse. The breakdown wasn't just a single bad judge at the trial level. The entire chain of justice failed.
In Qwen, the AI model developed by Alibaba actually graded this failure, didn't it? It processed the case like a rubric for legal compliance.
It did, and it gave the legal foundation of this entire process a dismal score of 2.4 out of 10.
2.4 out of 10, that's
A catastrophic failure by any objective metric.
So what were the actual steps of that collapse?
The AI models documented a cascading chain of errors. First, the trial was held in secret. Now, courts can hold closed-door trials for extreme circumstances, like national security or protecting a minor's privacy, but the court provided zero legal justification for closing Dr. Chen's trial to the public. Second, you have the initial police raid. They forced the surrender of his digital passwords without a proper warrant, extracting temporary, cached images from his browser history, and legally categorizing them as published material.
Okay, but the part that absolutely floored me was the second instance ruling the appellate court. Because an appellate court's entire purpose is to review the lower court's math, right? To catch these exact types of errors. But they didn't even hold a hearing.
No witnesses called. No oral arguments permitted.
They just rejected his appeal with a written statement, and the justification they used was mind-boggling. They wrote, "The appellant did not submit new evidence to prove his appeal." Wait, he is locked in a prison cell.
Yeah.
How can an appellate court demand a man in a cage magically gather new evidence to prove his own innocence? Isn't it the prosecution's job to prove he's guilty?
This raises an important question about the mechanisms of power. What the appellate court did was a total reversal of the burden of proof. It is the absolute destruction of the presumption of innocence.
Right.
In a functioning legal system, you don't have to prove you are innocent. The state carries the burden of proving you are guilty. By demanding Dr. Chen prove his innocence from a jail cell, the appellate court completely abandoned its legal duty to review the lower court's errors.
And ChatGPT pointed out that this was the exact moment the legal process was revealed to be an empty shell.
It's a perfect description of how the mechanism works.
Sure.
The procedure was no longer functioning as an engine to discover truth or test evidence. It was functioning purely to launder a pre-decided political conclusion into a legitimate-looking legal reality.
Wow.
The aesthetic of a trial was the robes, the gavels, the stamped paperwork, but the actual substance of law, the causality and logic, had been entirely hollowed out.
So, what does this all mean? We've gone deep into the weeds of network physics, Chinese jurisprudence, and algorithmic logic. But why should you, the listener, tuning in right now from your car or your kitchen, care about a 100-follower Twitter account on the other side of the world? Why does Dr. Chen's story matter?
If we connect this to the bigger picture, we have to look at Grok's macro analysis. Grok zoomed out from the specific legal codes and looked at the sociological implications. This isn't just a story about one man getting an unfair trial. It's about a highly engineered chilling effect on the global marketplace of ideas.
The chilling effect. This is the mechanism where a state realizes they don't have to arrest millions of people to control a narrative. They just have to arrest one person very publicly and very unfairly, and the millions will silence themselves out of fear.
Exactly. When the law becomes a fluid weapon, when simply possessing a PhD and retweeting a cartoon is enough to guarantee a prison sentence, it fundamentally threatens human civilization's capacity for critical thought.
Because it targets the intellect itself.
Think about it. Human progress requires skepticism. Science requires the ability to look at a complex system, question the official narrative, and say, maybe this is wrong. Let's test it.
But if a court tells you that your intelligence and your skepticism are the exact things that make you a criminal light,
then you criminalize the very act of doubting. And when you criminalize doubt, you freeze civilization in place. It's a terrifying precedent. Grok actually cited the Universal Declaration of Human Rights in its output, noting that this legal framework represents a direct assault on the fundamental freedom to hold opinions without interference.
It is just wild to me to step back and look at our sources today. We fed these harrowing, blood-stained documents into machines, cold processors, billions of weights and biases, pure mathematics.
Yeah.
And all 6 of them, independently, arrived at the exact same conclusion about human dignity, freedom of thought, and legal fairness.
They mapped the logic trees and instantly recognized the absence of evidence, the fabrication of intent, and the presence of arbitrary, unchecked power.
I want to leave you with a final thought to mull over as you go about the rest of your day. Think about the profound irony here. We used artificial intelligence to analyze the behavior of a human legal system.
Right.
And all 6 algorithms instantly recognized the vital importance of human rights. They recognized the absolute necessity of the presumption of innocence. They saw right through the logical fallacies and the empty shell of a human court.
Striking.
What does it say about our society and the systems of power governing us when cold, emotionless algorithms possess a clearer, more deeply rooted understanding of justice and the spirit of the law than the human beings actually swinging the gavel? When human justice becomes this murky, maybe we really do need the cold precision of a machine to show us exactly where we've broken the equation. Thanks for joining us on this deep dive.